Well, the Supreme Court deciding on the fate of over 17 lakh students studying across 16,000 madrasas in one of the largest states of the country, that's the state of Uttar Pradesh. The Supreme Court shining light at the end of the tunnel, upholding the constitutionality of the UP Board for Madrasa Education Act, and in doing so, allowing that legal sanction for madrasas to continue to operate, over 16,000 of them in the state of Uttar Pradesh. Now, bear in mind, this was a piece of legislation, the UP Board of Madrasa Education Act, that was introduced way back in 2004. That's the time when Samajwadi Party was in rule. Over the years, it has faced multiple legal questions. It came to light once again in March of 2024 when the Allahabad High Court had struck this piece of legislation down, had questioned the operations of madrasas, had raised questions of unconstitutionality, had raised questions of non-conformity with the secular fabric of the country, and had in fact asked for the state of UP to accommodate these over 17 lakh students into regular schools. Now, that is a piece of order. That was one order of the Allahabad High Court that was challenged here before the Apex Court. Multiple questions were raised about the legal sanctity of these madrasas, but importantly, the Apex Court has given its clarity that the madrasa legislation is concerned. It is reasonable, it is constitutionally consistent, that it is consistent with the state administration, with the state's objective of achieving academic excellence. That is the aim and purpose of madrasas, and on that ground, the constitutionality has been upheld. The Supreme Court further clarifying that this is also consistent with the state government's objective of having a minimum level of competency as far as the candidates themselves are concerned. However, on the back of that, there are three important clarifications that the Supreme Court has given. Number one, as far as setting of standards is concerned, the Supreme Court says that religious institutions, especially run by minorities, are free to administer education, but at the same time, the standards will be set by the central government, the standards will be set by the state government. Standards for examination, standards for teachers, that can be set by the state. That is not inconsistent, that does not come in the way of religious minorities running these educational institutions. That's one. The second is, what about religious teachings in these minority institutions? On that question, the Apex Court has clarified that, again, these being minority institutions, they're free to impart religious teachings, but at no point can a student, can a candidate be compelled to participate in those religious teachings. That's the second key clarification. The third key clarification, perhaps the most significant of the three, bear in mind that this UP Madrasa Act, this piece of legislation, runs across not just schools, but also higher education, and that is why the Supreme Court has come in saying that as far as higher education is concerned, it is governed entirely by UGC regulations, that this madrasa legislation is inconsistent with those UGC rules, and therefore, at least as far as higher education is concerned, that is not a place where this madrasa legislation can operate, that is not where madrasas can impart education, and to that count, the Supreme Court has held this madrasa legislation for higher education to be unconstitutional, saying that good for schools, not for higher education. That's the final clarification coming in from the Apex Court, again giving clarity to over 17 lakh students across 16,000 madrasas in the state of Uttar Pradesh.
For more news and updates, all you need to do is follow CNBC TV18 on all of our digital platforms.